And so we welcome to the program Byron Henry. He is an attorney with the Scheef Stone law firm out of Dallas, actually. His areas of practice, employment litigation, professional liability, among others. And welcome to the program, sir. How are you?
I'm doing well. Great to be with you.
So, first off, how closely have you been following this story? Is it just something that it just popped onto your radar screen, or how long have you been following, like since the beginning of it, like a month or so ago?
Well, I've been following the North Carolina bathroom bill, so-called bathroom law story for a while, but we also had the same thing happen down here in Texas. I don't know if it got reported up there, but Houston passed a city ordinance doing about the same thing as the Charlotte ordinance was purporting, and the city council passed an ordinance, and it was subject to a ballot measure that sort of like a recall petition, where it was sent to the citizens and repealed by popular vote after the city council passed it. So we had this episode over the last election down in the city of Houston. So this issue is popping up in lots of places, not just North Carolina.
I'm sure that's all completely coincidental, right? Just the issues popping up all over the place. There's nothing, we are to draw no conclusions from any of this. That was the HERO, right? The HERO bill or the HERO law down in Houston?
That's exactly right. And, of course, something else we have going on in Texas now, the Target boycott that is going on with respect to Target internally changing its policies, and the American Family Association has the 1 million plus signers onto a boycott. Well, our Attorney General, Ken Paxton, sent a letter to Target requesting that they disclose what policies they put in place to protect women and children in the privacy of the restrooms in their stores, so as to kind of quell some of the concerns by the citizenry. And, of course, Target has yet to respond, but we're waiting on that as well.
So the Obama administration says that House Bill 2 that requires state employees in public government buildings and students in the universities to use a restroom, locker room, and shower facility that match their biological sex is now in violation of federal law. And the administration has not only staked out its position for North Carolina, but for all states, universities, and most employers in the United States. That's according to the governor's office. Is that the way you see it?
Yes, they are taking the position, the federal government, Obama administration is taking the position that by requiring persons, without regard to their actual gender or gender identity, to use the restroom that corresponds with the gender on their birth certificate, that somehow that violates the Civil Rights Act that bans or basically prohibits discrimination based on sex.
And as I understand it, there is, especially over the Department of Ed, but I don't know if that's your expertise area, your focus is on the employment side, right? Would that be, Title VII, correct? That's the aspect that you're...
Yeah, Title VII.
Okay.
And the constitutional interlock between those, yes.
Okay, great. So, so the Title VII component and the EEOC is cited in this letter by the DOJ, and apparently they're citing some sort of an opinion that's the primary foundation for this assertion. Do I have that right?
That's right. It's an internal rule-making authority that when you have the law doesn't change, by the way. The Civil Rights Act is the Civil Rights Act both you and I and everyone in the country knows and loves with respect to race, gender, sex, national origin, religion, all the classic protected classifications that we all know about. But when an administration comes in that tends to look at the law one way, they write opinions internally that say, oh, that also includes X and Y. For instance, there's been a push by a lot in the LGBT community to have the government declare that sex includes sexual orientation.
Right.
But unfortunately, both courts and most internal memos and opinions have said, no, the law needs to be changed to include sexual orientation in the Civil Rights Act. Most people that have analyzed it would agree that gender identity or transgender, the law needs to be changed to include that. They can't just by rulemaking authority decide one day, oh, yeah, sex includes transgender and gender identity as well. And that's what seems to have happened here under the Obama administration, is internally they've decided that they believe the law, the word because of sex or based on sex, includes a transgender or gender identity.
Which is an amazing thing. If that were the case, why is Al Franken every single year trying to introduce legislation to change the SOGI or to include the SOGI protections in the Civil Rights Act? If it's already there, why would there need to be a law to change it?
Exactly, and most people do not I'll say this, not most people don't believe it's there. Most experts think that the law needs to be amended to include sexual orientation, and it's the same. Almost every state has similar laws as well, and none of the state courts, at least most, believe that based on gender or based on sex means sexual orientation or gender identity. And there's not a lot of opinions on that yet. Very few people make the argument because most people have agreed that it is not included. The law needs to be changed. So I'd also like to point out that this bathroom law had a lot of other sweeping provisions with respect to anti-discrimination ordinances and the power of cities and counties that aren't affected by this letter. This letter deals only with the use of bathroom and other facilities separated by sex in public by public employees and at public buildings and public institutions.
Right. Yeah, there were. HB2 did more than just the bathroom stuff, but it was sort of this preemption. It was an approach that said, look, you cities, you never had this ability to expand your authority into these areas of commerce and trade and employment. You didn't have that authority. Sort of, this North Carolina is like a mother may I state. Not a lot. It's Dillon's rule state. So there's everything the cities and counties want to do has got to go through the state legislature first. And people are outraged that the state came back and said you can't do these things. But yes, that's a whole separate issue. And you're exactly right. That's not the minimum wage component. That stuff is not addressed in these letters. Have you read House Bill 2? I'm assuming you have. You sound like you have.
Well, I'm familiar with the provisions, and each one of the provisions, specifically the provision here that deals with using restrooms according to or based on your birth certificate. And I would simply say that there are many more distinctions based on gender other than bathrooms at colleges, universities, and public buildings and public benefits. That means basically, how would you have, for instance, at a university, for instance, how do you have separate sports teams by male and female, and how do you determine male and female? Have we now decided that whatever gender you believe you are, that's what sports teams you can play on? Because that's what this letter means. Because the Civil Rights Act doesn't deal with bathrooms. It deals with any discrimination based on sex at all. Mm-hmm. And so if this is discrimination to distinguish between individuals based on the gender on their birth certificate, then every instance of the public or the state discriminating based on birth certificate specified gender is discrimination.
Well, yeah, it must be. Although, to answer your question, schools have already gone down this road. There's a lawsuit. We'll talk about it later in the program. Actually, there's a lawsuit filed in Illinois. You may be aware of this. This is the girls at this school, District 211. They're the district and the Department of Education being sued now because these girls were forced to disrobe in front of a transgender student who, by the way, is on the gymnastics team, the women's gymnastics team. So we're already down that path. It seems like.
Well, certainly, and the question here is not, it's kind of the question is interesting. It's not whether or not a school or a public university could break down all barriers between their sports teams. Whether they're allowed to, if they want to and they think it's good policy, that's a good argument for the legislature and for your show. But the question is whether or not they have to break down, as a matter of federal law, break down all distinctions between gender identity based on birth certificate or biological gender throughout society, including sports teams and many other things. We could come up with a lot of hypotheticals. So that's really the question, not whether you're allowed to, but whether federal law mandates that you must. And that's what this letter seems to say, that you are in violation of federal law and you must allow these people to act and participate and have their accommodations in public based on their gender identity and not their birth certificate.
So does this then become grounds for, does this become the test case? Is this the test case? Is this one going to the Fourth Circuit? Is this one going to the Supreme Court? Is this we're finally going to get a definition of what is sex and whether or not gender fluidity is part of it?
Well, that's the funny thing is that because of sex, there are so many cases out there on because of sex. I mean, the Supreme Court has, half a dozen, and all the courts of appeals across the country have dozens, maybe hundreds of decisions based on because of sex, including sexual orientation claims that were made. And so I would say it probably is a test case for this one specific narrow issue of bathrooms and gender identity. But the question has basically been answered that if you want the federal civil rights law to apply to transgender issues and sexual orientation, the law needs to be amended. And this would not be the first court to say that. And, of course, no lawsuit has even been filed in this case. This is the opening salvo by the federal government to hoping that North Carolina will crater, basically, and say, okay, we don't want to jeopardize federal funding. We don't want to get into a lawsuit. We'll agree to your demands. And that's so it's a while down the road to get to litigation and
right.
to get to, and of course, a new president, whether it be Hillary Clinton, Donald Trump, or whoever else it may be, based on this crazy political season, might take a different view of take a different view of the Civil Rights Act and say, no, we don't believe. We're not going to take that position. We're going to internally write a rule that says the law needs to be amended before we can enforce it with respect to transgender. So a change in president also, a change in the Civil Rights Division also could affect a change in policy.
Right. And then, of course, obviously the absence of Antonin Scalia on the Supreme Court, it being a 4-4 split. And if something does get through the court system before a replacement is named, I don't know how that would actually happen. It would have to be, seems to me like really accelerated for that to happen. But if that were to be the case, you end up with a 4-4 lower court ruling standing, it sounds like.
It would take this case enough time where hopefully you would think there would be a Supreme Court justice named and confirmed before the next term, which starts the following October. So you would think there would be a new Supreme Court justice. But you're exactly right. If there is a ruling that is against North Carolina in the federal courts and it goes to the Supreme Court, a 4-4 split would affirm the ruling against North Carolina until a later Supreme Court decision with the right complement of justices could be heard and decided.
And this would be running through the Fourth Circuit, which used to be one of the most conservative, if not the most conservative circuit in America. Not so much anymore, thanks to the last 8 years. But you've got now the Fourth Circuit that just ruled on the school funding case. This was a transgender kid wanted into the other bathrooms. Not satisfied with the accommodations that the district provided, and it was the same rationale. The Department of Ed relying on the same sort of interpretation to tell that school district, you've got to do this or you're going to risk your money. It's extortion, as I see it. I mean, it's like, and it's a perfect illustration of why the Republicans, when they promised to abolish the Department of Ed, should have done so when they had the chance, because this is sort of the rulemaking process at the top. And then you get hooked on the money, and then they use the money as leverage to get you to comply with their rules. That's what it seems like to me.
Of course, and I think that's your test case, because it's basically the same argument. I know it's a different provision of the law.
Right.
It's the Department of Education, but I think that's more the test case, at least a test of how the full newly constituted Fourth Circuit is going to view this question that's been decided by other courts of appeals, like I said, on a number of occasions, and are they going to take the more established position that the law needs to be amended to include these issues, or can they just, become enlightened overnight and decide, oh no, it's always included these gender identity and sexual orientation? And so that's a better test case, and it's upcoming soon, and that would give you a good preview of how the Fourth Circuit would address this case if it ever came to them.
Yeah, well, yeah, I mean, who could argue that the politicians back in the early 70s totally meant to include gender identity when they said sex? That just seems so rational.
As you mentioned, so many Democratic senators and some moderate Republicans as well have argued for the amendment and said we need to update this law because it does not provide the protections for gays, lesbians, transgenders, and bisexual individuals, that they're asking to amend the law, and it's been on the floor of the Senate. There's been articles written. There's been bills introduced, you name it. So that's the position that's been taken for at least the last decade, if not longer, about the state of the civil rights laws. And in the states, they've taken the same positions as well. So it seems to be sort of a turnabout here. So we'll have to wait and see. So
last question here, Counselor. Do you see any problem with the House Bill 2 provisions from a legal standpoint? Do you see them as unconstitutional?
Barring some provision of North Carolina law that gives some sort of discretion or authority to the universities as an entity or a school district as an entity, the view is that the state legislature generally has the plenary power to set the policy. And it seems to be neutral and non-discriminatory, and that it doesn't matter if you're gay, lesbian, bisexual, transgender, or heterosexual. Whatever it says on your birth certificate controls which restroom you use. So it seems to be neutral on its face, and it also seems to be within their authority to set policy for public and state agencies and buildings. So at least from that standpoint, if you take away the civil rights aspect of it from the administration, it seems to otherwise pass legal muster.
Okay. Hey, we appreciate your time. Thanks so much for lending your expertise to us. Hope to call on you again. Byron Henry, and he is with Scheef Stone Law Firm out of, you're with the Dallas, Texas? You're out of Dallas, Texas?
The firm's based in Dallas. I'm actually up north in North Dallas,
Okay.
in Collin County, in a little town called Frisco, Texas.
Oh, okay. Frisco, Texas. All right. Well, thank you very much. We appreciate your time, sir.
Thank you, too. Bye.
All right. Take care.